Hey, real quick, before we dive into today's episode, if you've been feeling like your brand needs a little love, but you're not quite sure where to start, I have just the tool you need. The Standout Brand Audit Bot is an AI-powered guided audit that shows you exactly what's working, what's not, and how to strengthen your brand using my proven Standout brand system. In 10 minutes or less, you'll walk away with clear next steps to move your brand forward with purpose. It's completely free. Just head to the show notes to grab the link and get started. Lauren Bercuson is a trademark attorney, brand protector, storyteller, and advocate for female founders who are serious about locking in what they're building. As the founder of StoryLock Legal, Lauren helps entrepreneurs safeguard the names, logos, taglines, and creative assets that they've worked so hard to create, making sure their brands are actually theirs. With nearly 2 decades of experience in trademark law, she blends legal strategy with creativity, which makes this conversation way more interesting than you might think from a legal training. In this training, pulled directly from the Six Figure Brand Society Vault, Lauren breaks down the different types of intellectual property, why trademarks matter more than most business owners realize, when to file and when to wait, how to choose a strong distinctive name, and why a comprehensive trademark search is a non-negotiable before you build your entire business around a brand. If you're building something you want to last, not just something that looks good on the internet, this episode is going to be really, really important for you. Welcome to the Six Figure Brand Podcast, where each week we're pulling back the curtain on what it really takes to build a six-figure business as an online service provider. I'm your host, Morgan. I'm a branding expert, online agency owner, mom of 2, and military spouse, and I'm obsessed with helping entrepreneurs like you understand the ins and outs of branding so that you can use it to grow your business without sacrificing your sanity. Whether you're just starting out or focused on scaling, we're diving into everything you need to build a profitable and sustainable online business. Let's get to it.
My name is Lauren Bercuson. I am an attorney in Miami. I started practicing trademark law in 2005. I was trained at one of the top IP boutique firms in Miami, and then did some commercial litigation for a little while, clerked for an appellate court judge for a little while, took some time away from the law when my kids were born, and that's probably my number one job, is being a mom of 2 boys that are 10 and 12. And I'm also a writer, and like all of you, I am a small business owner because this is my own practice. It's just me. And I've been up and running for about 2 years now, and it's been great. But the entrepreneurial journey is a journey. It's not always easy, ups and downs. And I know that we all can relate to that. So today we are going to talk about the types of intellectual property. I'm going to give you an overview, and then we're going to really delve into trademark law because that is the heart of what I do, and I love talking trademarks. So as you guys may know, there are many types of intellectual property. And it's not uncommon to confuse these frequently. So many of my potential clients will come to me and they'll say, I want to copyright my name, or I need to patent my brand. So let's just clear up before we go any farther. Okay, so first, a trademark is any kind of a brand element that identifies the source of goods or services. So let's talk Nike, for example, because that's always the perfect, example. Nike, obviously, you see the word Nike on a piece of clothing or a product, you know the source of the goods, right? You know it's Nike's corporation. Just hearing the word Nike alone, you conjure a whole story in your mind, right? Of powerful athletes, quality products, all of it. Other trademarks owned by Nike, the Nike swoosh, the slogan, just do it, Air Max, Dry Fit. These are all trademarks owned by the Nike's company that all identify Nike as the source of those goods and services. So trademarks, think of as your source identifiers, names, logos, slogans. Copyright, on the other hand, is a different animal. Copyright protects your creative works. So if you are a novelist, if you're writing music, if you're a performer, if you have a podcast, if you created a course, those works are all subject to copyright protection. And copyright protection attaches as soon as the work is created. So essentially, it's called when a work is affixed to a tangible medium. As soon as a human creates that work, copyright attaches. But if somebody ever takes your work and tries to pass it off as their own, and you need to bring an action against that person, well, in that case, you would need to have taken it one step further and have filed for a copyright registration. So essentially, it's very easy. You file at the U.S. Copyright Office. It's an online application, but you need to have filed an application and to have gotten a registration in order to bring action if your copyright is infringed. So just think copyright protects your creative works. And then finally, you have your patents. Patents are for inventions, technological advancements, unique product functionalities. So as an example, like this mouse, right? And the ergonomic design, like this is all something that would be patent protected. It's the invention itself and the technology. So trademark, names, logos, businesses, those are your source identifiers. Copyright, creative works, and patent for your inventions. Everyone good? Okay. So what is a trademark? So a trademark, as we said, can be a word, a phrase, a symbol that identifies your goods and services. So there's even other things that can be trademarked as well. So as we said, a word like Nike, that's a trademark. A phrase like just do it. Breakfast of Champions, my favorite. Do you guys have K Jewelers by you? Anyone? K Jewelers, like ever since I was a little girl, this is why I'm like such a dork. When I heard every kiss begins with K, I was like, that is the most clever tagline ever. That is a fantastic trademark. Like you hear that, you know exactly where, that the jewelry is coming from. So logos are also strong source identifiers. So think of the Nike swoosh, think of the apple, the NBC peacock. One that everyone knows is the Lululemon, like that like swirly, round swirly thing, right? You don't even need to see the word Lululemon or the word Nike to know that those logos belong, are identifying those companies as the source of the goods and services. Colors can also be trademarked. So Tiffany, one of the most famous ones, that shade of blue, that is a trademarked color owned by Tiffany. So if you're a jewelry store and you start using that color blue in your branding, no, you're going to get a cease and desist letter. Tiffany owns that color. Another one that's popular is, do you know the fancy shoes Christian Louboutin with the red soles? So that red sole is a trademark. It's actually a hot source of litigation around many countries. In some countries, it is considered a trademark. In others, it is not. But that red sole. If you see that red sole, you know that it's a Christian Louboutin shoe. Sounds can be trademarked. So think about the NBC chimes. Dun, dun, dun. Pardon my voice there, but that is a trademark sound because if you hear that sound, you know you're on an NBC, you know you're watching NBC. So again, symbols, designs, and even characters can be trademarked. So something like Mickey Mouse, right, is a source identifier for Disney. It is a trademark. It is also subject to copyright registration because it's a piece of art. So there are some things that can serve dual purposes. But most common, of course, are the words, your taglines, and your logos. Those are the ones that most people want to protect in their businesses. All right, so what? Why do trademarks even matter? And this is what I get asked all the time. If you don't actually have a trademark registration, you don't truly own your brand. So what do I mean by that? If you have a trademark registration, that means that you are the legal owner of that mark, the whatever mark you registered in connection with whatever goods and services you registered for all around the United States. So it gives you automatic legal leverage. So if anybody tries to come after you saying that, you're infringing, all you have to do is hold up your trademark registration and say, no, I'm not. And then the burden's on them to prove that there's an issue. You also can easily try to stop copycats because, again, all you have to do, hold up that trademark registration to let others know that you're infringing on that they're infringing on your mark. So it's a big source of deterrence because a lot of times if a copycat sees that registration symbol at the end of your brand name, they're going to know not to mess with you. So you have that legal leverage, you have ownership, and then it also builds trust with your customers. If you were deciding between two companies and you weren't really sure, and for all intents and purposes, they were the same, if one of them has the R at the end, you might, not intentionally, but you're probably going to lean more towards that business because it seems more legit, right? It just builds a lot of trust with your customers. And then of course it's brand recognition, authenticity. People know that if they're buying a Lululemon product, they know the quality, they know how it's going to probably look and feel, and they just know it's going to be a good product because Lululemon polices their mark. They protect their mark. They make sure there's no copycats. They make sure that all of their quality, everything is always the same. So trademarks, when you have a registered trademark, it tells people that you can trust us as a company. And the other thing that's really great to know about trademarks is that they're value adds. So if you are looking to build your company with an exit strategy in mind, any trademark that you have, any registration increases the value of your company. Trademarks can be licensed and monetized, and so they truly, truly increase your value. And that's a huge asset. Or if you or a client of yours is looking to potentially bring on investors, you really want to have your IP secured because that's going to make your company a lot more appealing. So, and before I continue, this registration symbol, the R in the circle, you cannot use that symbol unless you have a federally registered trademark. Until you have that, you can only use the little letters TM, which I'm sure you've seen in the top right or the bottom right shoulder of the mark. But this R symbol is exclusively reserved for trademark owners, registered trademark owners. Any questions so far? All right. So this is one of my favorite things to talk about is picking a strong mark. So many times people will come into my office and they'll say, I want to trademark my name, and their name is very descriptive of their services. So as an example, PR Blueprint Coach. Okay. You hear PR Blueprint Coach, you know exactly what they're doing. You know that they're going to give you like a strategic roadmap, and it's not very distinctive. Why? Because if you look up PR Blueprint, you're going to find a gajillion companies because it's descriptive of the services. So when picking a trademark, and how I counsel my clients is you always want to be as distinctive and unique as possible. If somebody is looking for your company, or if you're a brand strategist, one of your clients' companies, you want people that are looking for that client to land on that client's website or page, right? Or your website or page. You don't want them going somewhere else because of confusion. So there is in trademark law what's called the trademark spectrum of distinctiveness. And on one end of that spectrum are your very weak generic marks, and on the other end are your really strong fanciful marks. So generic marks are marks like aspirin, like cookie for a cookie. You can't register or apply to register the word cookie for a cookie. Simply put, you can't stop somebody else from using the word cookie if they are in fact making or selling cookies. You just can't do it. So that happens fairly often. And brands actually, even once trademarked, have to be very careful that their brand name doesn't become the common name for a product, because then you're in jeopardy of losing your trademark rights. So as an example, Band-Aid, right, is always in jeopardy of losing their trademark because whoever asks for an adhesive bandage, right? Someone cuts themselves, you ask for a Band-Aid. Well, that's great in some ways because everyone thinks of Band-Aid, but at the same time, if the name becomes genericized, then that's a problem because then anyone can use the word Band-Aid. So as an example, jet ski was a trademark that they eventually lost it because that became the common term. I want to say escalator. Xerox might have been one. There's a few. So it just goes to show that you want a strong trademark, but you don't want it to become like the thing that everyone uses. You have to, as a trademark owner, you have to actually police and audit the marketplace to make sure that people aren't using your name in connection with their own products. So those are generic marks. Aspirin is an interesting one as well, because in some countries it is not considered generic, in others it is. So like if you're in the United States, you'll see it's not aspirin, it's Bayer aspirin. And the Bayer is where the trademark is, the registration. All right. So then we have descriptive marks. So unlike generic, where it would just be like the word for what you're trying to sell, descriptive usually gives a little more, but they're still not strong marks. So the Container Store, right? It's honestly a terrible trademark. And the only reason that they were eventually able to get protection in their mark is because they were eventually able to show that the mark was famous. That after their long use and, they have all this advertising strategy and budget, and people in the country know that when you say the Container Store, you are talking about this one specific white and blue looking store, right? It is very hard to get descriptive marks registered without showing that fame. It's not going to happen. It is also very hard to make a name for yourself with a descriptive mark. So that's where clients often come to me and, they have marks that are going to be very difficult to register. And so we'll work together to kind of create something that's a little bit more distinctive, but it's hard. And I get it. People want to immediately convey what it is they're offering for sale to customers. And they also think that for SEO purposes, it's better for your brand name to immediately tell what it is that you're offering for sale. But there are many other ways that you can do this. So descriptive marks are simply marks that describe the product or service. As an example, for many years on the side after my kids were born, I am a huge reader and a writer, and I blogged and reviewed children's books on the side. And my blog took off. I was getting, boxes of books by the day by the major publishers. And my blog had a crazy name. My blog was called Happily Ever Elephants because my son, my oldest, who's now 12, when he was a toddler, and we would finish a book, he would say, and they lived happily ever elephants. No idea why, but it stuck, and that became the name of my blog. Well, guess what? In a world of blogs that were, I love kids books. I love reading. Kids books rocks. Mommy loves kids books. The best kids books, my blog stood out because I was the one that was memorable. And even though Happily Ever Elephants doesn't tell you what the services were, I created the association through great branding and great messaging, and telling my story, which connected to customers. And then it became known that that was my blog, and my blog was a children's book blog and not like an elephant sanctuary. So these are things that you really want to consider, especially for brand strategists, or if you're starting a new company, whatever it may be, because you want your brands to be as distinct as possible. So generic marks, descriptive marks, you're not going to get protection. Moving along the line where we start getting much more fun and much more distinctive is suggestive marks. Suggestive marks don't exactly tell you what goods and services you're offering. They basically will require the customer to kind of like think and take an extra step in their head, like trying to make a connection between the name and the product. So copper tone, you don't know that it's sunscreen, but it creates, some kind of thought that maybe it's something that will leave like a copper tone on something, right? Without directly telling you what it is. Another super popular one, Netflix, makes you think maybe something about movies, maybe something about the internet, but it doesn't tell you what the services are. My brand name could be suggestive. StoryLock Legal. I always say that the best trademarks tell great stories, because if there's a strong trademark, you can immediately in your head think about a million things about the brand, just because you're so, it's so distinctive. And if it's Nike, like you can see the athletes, you can see, the sweat, the muscles, the hard work, the runners, they just tell a story, right? So I say every brand tells a story, and I help business owners lock in those stories so that they're protected forever. So that's a suggestive name. So suggestive marks are great. Another good one, Jaguar. allegedly they named their cars Jaguar. They named the business Jaguar because Jaguars are the fastest and sleekest animals, and Jaguars are fast and sleek cars. So suggestive marks are really, really fun. And especially for the namers and the brand strategists in the room, it's a really great exercise for clients to think about, ask them to think about how you want someone to feel or what kind of ease they're going to get from working with you. Or, there's a bunch of different exercises that you can do to kind of.
Is your brand feeling a little off? Like your visuals, messaging, and your overall vibe just are not lining up with where your business is headed? You probably don't need another pretty logo. You actually need a solid strategy behind your brand. That's exactly what we'll build together inside the Standout Brand Strategy session, a one-on-one deep dive into your brand foundation so that you can finally show up with clarity, consistency, and confidence. And if you're thinking about working with Spect & Co. on branding or web design, this is your first step for every single project that we do together. Clients who've gone through this process have tripled their audience size, doubled their revenue, and raised their rates by 30% or more. Use the link in the show notes to book your session, and don't forget to enter code SFBPOD at checkout to save $100.
Get away from the descriptive nature of a good or a service. Okay, next, your strongest marks are going to be your arbitrary and fanciful marks. Arbitrary is taking one word with one meaning and smacking it on something else with no apparent, relationship. Obviously, the one that we all know the best, Apple for computers. Apples have nothing to do with technology. Allegedly, there was a story that the computers were being created for school and something with the apple and the teacher. I have no idea. Even still, as my grandmother would say, that's a booba mice, which is a made up story. Don't know if that's true or not, but whatever, it works either way. Apple has nothing to do with computers. Another one that's super popular is Dove for soap or Dove for chocolate. Maybe you can kind of make a connection to soap, possibly, white, soft, I don't know. But Dove has nothing to do with chocolate, right? It's an arbitrary mark. So those are fun. And then your strongest marks are always going to be your fanciful marks. And these are, simply put, they're made up terms. So Pepsi, fanciful term, it's made up. That's going to be your strongest bet. Lululemon was a made up term. Xerox was a made up term. Kodak was a made up term. Those marks are always going to garner the most protection, the broadest protection, and they're going to be you're going to have a much easier time enforcing those marks against infringers. So that's naming. Any questions so far? No? All right. So moving along, once you have your name, you want to conduct a comprehensive clearance search. I always say that this is arguably one of, if not the most important parts of starting your business. And while some people laugh, the reason that I say that is because you should never build a business on a name that you don't own. That's the bottom line. You would never, and I remember 20 years ago, my first boss sat me and the other new associates down and said to us, think of your trademark like a house, right? You would never, ever walk up to a piece of land and just start building a house on it. You don't know who owns it. You don't know if the foundation's safe. You don't know the zoning laws, right? You would just never do that. It's way, way, way too risky. Building a brand around a name without clearing it and searching it is just as risky because there are so many things that can go wrong. And I'm not trying to say this to fearmonger, but when you're applying for a trademark or when you're looking at trademark law, the standard isn't just, is there an identical mark out there? The standard is whether one mark is likely to cause confusion with another mark. So that means that if your mark is Bluebird for cookies, right, and you spell it as you think it would be spelled, BLUEBIRD, right? One word. But then someone else tries to register Bluebird for cookies, but they think that they're smart and they spell it BLU space BYRD. Well, guess what? They might not have found an identical match in their own DIY search, but the PTO is going to tell you that you can't be registered. They're going to refuse the mark because they're going to say that it's likely to be confused with a mark that is already registered. Because if we're having a conversation and I'm giving you guys cookies and I tell you I got them from Bluebird, you have no idea if it's the Bluebird that's spelled properly or the Bluebird with the funky spelling. You just are going to think that they're the same. And that is exactly what trademark law and trademark registrations are designed to protect against. We don't want confusion in the marketplace. So the comprehensive trademark search is a step that should never be skipped. And first, it helps you see whether you're clear for registration in the Patent and Trademark Office. So we're looking at direct bars, phonetic equivalents, foreign equivalents, all sorts of data to determine whether we think your risk is high, medium, or low. And then based on that analysis, the client has a business decision. If it's a low risk mark, pretty easy to move forward. If it's medium, you can go either way. Some people want to go for it and are like, I'm going to fight it. I love the name. And if I get a refusal, we're going to fight it. And if they don't get it after all of that work, then maybe eventually they'll decide to rebrand, right? Especially if there's an existing registration. If there's an existing registration out there or an existing application, it's pretty risky, pretty big sign to not move forward because you're going to have problems or you're likely going to get hit with a cease and desist letter. That is not the way you want to start a new business. So we look at the records of the PTO, and then we look at what's called common law marks. Common law trademarks are marks that are in use, but they're not actually registered or they haven't been applied for registration. So why is that important? If you are a business owner and you haven't taken action to register your mark, you still are accruing rights in that name, right? So you still can stop anybody that comes after you from using that name. It'll just be harder because there's a much stronger burden of proof. But let's say that I'm StoryLock Legal and I didn't search, but I filed an application and I got a registration, right? But let's say that there's somebody on the West Coast that's operating StoryLock Law all up and down the West Coast, and I had no idea about them. But let's say that they started using StoryLock Law before I started using StoryLock Legal, but I got the trademark registration because they had never applied. Well, now they have to go to the Patent and Trademark Office and say, listen, PTO, Trademark Trial and Appeal Board, Lauren should not have this registration because I started using the mark before her. And now you're in a litigation battle because the owner, the first user in the US, trademark rights accrue based on first use. The first user should have been the rightful owner of the mark, but the PTO didn't know about them. So they gave the mark to me. And now they have to fight me for the mark. And now you're in a battle that could be tens of thousands, if not hundreds of thousands of dollars. So there are big ramifications for not applying and registering your mark and for not searching your mark because you don't want to get hit with a cease and desist letter because you were unintentionally infringing on someone else's brand. Any questions about this? I know that's a lot. All right. So why spend the money? As I said, we always want to be sure that when you're investing your heart and soul into a brand, you want to own the brand, right? So spending a small amount initially to clear and register and secure your trademark can potentially save you tens of thousands, if not hundreds of thousands of dollars down the road. Service-based businesses, it's awful, right? But if you're a product-based business, you're going to be in an even worse position because you're going to have all of your products, your product packaging, all your, not only your bottles or whatever it is that's on your product, but how you package and ship your product. I mean, everything, your website, your advertising, your marketing materials. It's so expensive to rebrand. And in addition to the money spent on advertising and marketing and product packaging, you're losing all of the goodwill that you built in that brand. And that's priceless, right? So now you have to go and you have to create a brand new association from the old name to the new name. And it's a big undertaking. So spending the money to do it right and starting smart in the beginning. And again, when I say it's a small investment, most trademark attorneys will charge about $2,500. And that's for clearing the mark, so the full comprehensive search, all of the conferencing back and forth, prepping the application, filing in the application, and then seeing that application ideally through to registration. So It usually it doesn't include filing fees, which are $350 per class. That's what you would have to pay the government, regardless of, any attorney. If there's like any kinds of refusals, that's usually a separate fee. If it's a substantive refusal and you have to prepare a legal argument. But $2,500 compared to 30, 40, 50, $100,000 is, not that bad. There's a big benefit to starting smart. Okay, so once you file your application, you wait for a really long time. So typically the process goes something like this. Do a trademark search. When it comes back clear, you're going to file your application. You can file two types of applications. You can either file a use-based application if you've already started using the mark in commerce. And using the mark in commerce does not mean that it's your social media handle and you've just shared about it on Instagram. It has to show that you're actually offering a good or a service in connection with the trademark. So you can do a use-based application, or you can do what's called an intent to use applications. And intent to use applications are terrific because it is the only time that you can get an earlier use date without actually using the mark. So as I said, trademark rights in the US accrue based on first use of the mark, right? So you have to be using the mark in commerce. But you can apply for a trademark and use an intent to use application, which basically is you telling the PTO, I haven't launched yet, but I'm taking actions to use this mark in connection with these goods and services. PTO loves these applications, right? And essentially it holds your place in line. So if you file your application today, April 24th, 2025, as an intent to use application, but you don't start using the mark, you don't start offering your services for, 2 years. Well, once you show the PTO evidence that you've started using the mark in commerce, your first use date is going to revert back to the date that you filed the application. So it's like the only loophole to getting an earlier first use date, which is a big advantage just in case there's any kind of infringement action. So basically, once you file your application, you wait a long time. It could be anywhere from 7 to 10 months before the PTO examining attorney even is assigned to and reviews your application. So that's where the waiting process comes in. And then one of two things can happen. You'll either get an office action response. Some of them are, non-substantive and you just have to clear up a couple things. Some of them are substantive, like the mark is descriptive or the mark is likely to cause confusion. And then you have to overcome that. You have to create an argument. Or the mark is going to sail through, looks good, and it's going to go to publication. There's a 30-day publication period once the mark is approved by the examiner. And that's the time where basically the PTO publishes the mark in the official gazette and tells the public, we approve this mark for registration. If you think you're going to be harmed by the registration of this mark, you have 30 days to speak up. And if not, we're going to register it. Once you pass through that phase, either your mark will register if you filed a use-based application, or if you filed the intent to use application, you have 6 months to prove to the PTO that you're using the mark, and you have to submit a specimen, like a evidence, like your website or a photograph of the product with the mark on it, to the PTO. You actually can file 5 extensions. So you basically, if you file an intent to use application, have about 3 years to start actually using the mark in commerce. You have to pay a small fee each time, but it is a huge advantage because you're securing your mark, and the second you launch, you're protected. So that's the process. So benefits of registration, as I said, you are officially the owner of brand. If you don't have a registration, you're kind of renting, right? That's kind of the way to look at it. You can use the registration symbol, which is a huge deterrent to copycats, and it becomes a valuable asset of your company that you can license, you can monetize. I mean, some of these big companies, like think about Nike, they make so much money from licensing. But even on a smaller level, if you're a course creator and you license your course to, say, business coaches across the world, that's a lot of passive income that you can bring in. So we can't only think about the big companies. We can think about these small, baby businesses that have created some great intellectual property and they are licensing others to use their products. They're allowing others to use what they've created. So big, big source of value. Finally, since I knew I was speaking to a bunch of ladies, some of my favorite women-owned trademarks. Spanx is always, a winner. Sarah Blakely is amazing. And if you can see here, not only does she have Spanx registered, you could see the registration symbol, but also her name. So you can register a name. HuffPost, Tory Burch, Rodan and Fields. There's so many great ones and women-owned businesses, So that brings us to the end of my presentation. If you are interested, you can click on the QR code with your phone. It's a free 6 email series that goes over what I talked about today, but even more in depth, and I think in a fun and, non-legally way, just kind of gives you a good overview of trademark law. And I offer free consultations. So if you have any questions, I would love to chat.
Lauren, can you tell us, for anyone who might be interested, what does hiring you to do this for us look like? Any trademark attorney, I guess.
So this is what I love. Trademark clearance and registration is my jam. I don't really litigate anymore. I'm been there, done that. I have 2 kids, not the lifestyle I want. It's very intense, but clearance and protection is so much fun because it allows me to combine the logic of, the law with creativity, which, as I said, I'm a writer and a creative. And so I love that piece of it. So typically when my clients hire me, sometimes they've really been in business for a while, but never protected themselves and just want to file a trademark application. Or oftentimes it's a business that is launching a new course or a new product or a new service line that they want to name. And so we need to protect that new offering. So my Trust Your Trademark package is it's such a dorky name, but whatever. That's what I came up with. And now it's my signature offer. And I'm gee, I really should name this something and try to trademark it. But so my Trust Your Trademark package is kind of my signature, and it's $2,500 for the investment. And that includes a full comprehensive clearance search of one mark. And so I will, as I said, I go through all the records of the Patent and Trademark Office, common law marks, and I will provide the client with a full anywhere from 8 to 20 page analysis of the data that we get to determine the risk level of adopting that particular mark. If the mark is clear, we go ahead, we file the application. That's obviously all included. All of our conferencing, all of our emailing back and forth is included. Don't turn on the clock. If somebody emails me or calls me and wants to just touch base, or if they don't understand something, that's not the way I practice. It's why I don't like, big box corporate law firms. If you're not understanding something and you're my client, then I'm doing something wrong. That's the way I feel. So all of our conferencing is included. And then we'll go ahead and get your application on file, and I'll see it through ideally to the end goal, which is registration. So if there is an issue with the mark and we need to come up with a new name, I do have to charge for another search if we're going to, depending on what the name is. If it's just adding a descriptive term because we think it's a crowded field and we want to just give you a little bit more of an edge, that's not necessarily going to result in a big fee. If it's a new mark, though, I will have to search and do another report. And that typically, depends on, it really depends on the database that we've already compiled and to see how much of that I can pull from, or if I need to do a totally new search. So a second search is not typically included, but PTO filing fees, that's a separate charge. That's $350 per class. So let's say you are a course creator and you also are, you've created your own platform, right? So your own software. So that would be 2 different classes because those are different categories of goods. So your application fee that we would have to pay upon filing to the USPTO would be $700 because it's $350 per class. So that's not included. The only other thing that's not included is if we happen to get a refusal from the examining attorney and they say your mark is confusingly similar to something else and we can't register you. In that case, we would have to fight if my client wanted to fight. And that, is obviously an additional fee. That being said, the purpose of doing that comprehensive search in the beginning is to be proactive rather than reactive. Because if I see something and I'm like, you're definitely going to get hit with this mark, you're not going to be able to register it. Or if I say these 3 marks could be deemed confusingly similar, then I'm going to tell you either there's no way you should proceed with this mark, or it's 50-50. There's a risk, but it's a business decision and it's up to you. I just had one of them where my client was like, I want to fight it. I was shocked and it went right through. I was like floored that it went right through with no issue. And then I had another one that looked like it was pretty low risk. There were a lot of other identical matches to her mark, but in very different industries. And it got flagged on services that were so different. So that's the hard part, is that it is subjective, right? What one examiner thinks is an issue, another one might not think is an issue. So there's never a guarantee. So we give you all of the data that we can to make sure that you're making, the best decision for your business, and to kind of let you know how much risk you can adopt.
Cool. All right. Well, thanks for your time, Lauren. And thanks everyone for joining us. Definitely follow Lauren on LinkedIn, whether or not you have any plans to get a trademark in the future.
Yes. And I would love to help any of you with your brands as well, if you are ready to do the trademark process.
Hey, Morgan here. I hope you enjoyed that training from the Six Figure Brand Society Vault. I know that talking with Lauren always opens my eyes to how important it is to make sure that my intellectual property and all of the things that I have worked so hard in my business to build are protected, and I hope that it's opened your eyes a little bit too. If you're interested in learning more about the Six Figure Brand Society, the links for all of that will be in the show notes, as well as all the links for you to connect with Lauren and learn more about how and why to trademark your business assets. Thanks for tuning in to the Six Figure Brand Podcast. If you enjoyed today's episode, please be sure to rate the show and leave a review on whatever app you're listening on. And as a thank you, I'll send you coffee on me. Yes, I'm serious. As a smaller show for now, you taking the time to do this makes a huge impact on how we can reach more people and how I can continue to create this content for free. When you take a screenshot of your review, follow and tag me on Instagram @SpectandCo. I'll send you a $5 Starbucks gift card. As always, don't forget to check out the show notes for any links or resources I mentioned during the episode. Thanks again for listening, and I'll catch you next week.